Good morning, everyone. We're just giving folks a couple of minutes here or seconds to trickle in. We'll be starting the presentation shortly. Okay, I think we'll go ahead and get started. I'll try to speak slowly with introductions, so we'll give folks a chance to get into the meeting. But I want to welcome you to our first quarterly sample policy update series. It's representing the policies that have been updated in our June 2022 packet. And so this will be an opportunity for you to engage with our policy team, as well as some of our legal services team. There'll be time and opportunity for question and answer. I'll start with a little bit of housekeeping about accessing the Q&A, and then we'll jump into introductions and get started with our presentation. So this morning we have the ability to ask question and answer. Many of you may already be familiar with Zoom. If not, welcome to the world of Zoom. We're going to try to answer all the questions as best we can. There's a feature down in the bottom of your toolbar that reflects a Q&A, and there's a little chat box there. So please do save your questions until the last 15 minutes of the presentation, and at that time we'll review them all. And some of them we can respond to live in the chat. Others will take an opportunity to answer live. All attendees will receive a link to the video of the webinar afterwards. So we'll also provide our contact information at the end if there are any questions that weren't able to get answered on the Zoom. So with that, I want to introduce you all to our lovely panel of experts today. With us, we have Bob Turk, who is the Chief Legal Counsel for CSBA, and that's for the District and County Offices of Education Legal Services, or Legal Services for short. I'm Tazita Stewarts. I am the Senior Director now of Policy and Governance Technology Services. We also have Barbara Leifman, who is our Senior Policy Manual Consultant, Mariela Martinez, who is our Senior Legal Services Attorney, as well as Alex Worthy, who is another Senior Legal Services Attorney. So we are going to get started and jump in. We're going to start off with some information about our legal services team, but briefly before we jump into that, I just want to give you guys an overview. This meeting today is going to reflect all of the policies or highlights of policies that we released in the June 2022 update packet. That release was pushed out through our software called Gamut. Many of you may already be subscribers. If you're not, please do reach out to us to inquire about subscriptions, or if you have any questions about your service and how to access the sample updates. Aside from that, we're going to give you highlights and kind of review the context and reason for most of the updates, as well as get into some of the legal specificities of each of the policy updates. So without further ado, I'm going to pass it over to Bob, who is going to walk us through legal services and a little bit about what we do or what they do as a department.
Thank you, Tazita, and good morning to all of you. Thank you for joining us. This is our first webinar, as she explained, of this new series. Very excited about this collaboration between our policy team and the new legal services department. We're hoping we'll be able to provide you with a lot more in-depth information about our quarterly policy updates, both in terms of the policy language and some of the ramifications that it may have for your districts in terms of legalities, implementation, and just generally answering the questions you might have about some of these updates. As many of you know, we do update approximately 100 to 125 policies each year. Some of these are brand new policies, like one we'll talk about today. Others are revisions that reflect new laws and changes in practice, or sometimes important cases and legal opinions that have come out that are going to influence policies. We won't be able to cover every single one of those updates during these webinar series. So instead, what we'll be doing is focusing on specific policies from the most recent update packet. The June one is Tazita just described. And with the time that we're allowed, we're going to discuss the specific changes to individual policies that we think are the most important to highlight, or maybe they've got the more complicated changes or the more far-reaching implications for your district. So that's going to be kind of our focus on this. And then if you have any questions on policies that we don't cover, please feel free to submit those using the Q&A feature or contact us after the webinar. We'll be happy to answer any of those questions as well. So with that, let me start off with explaining to you first just a little bit about what Legal Services is, because it is a brand new program, and I'll tell you why we're a part of this webinar. So this is a new program that we launched at our annual education conference. And Tazita, if you could advance the slide, please. The program is really a low-cost subscription program that we have created as an additional benefit for our members in response to a lot of the requests that we've gotten from members, both school board members, superintendents, cabinet level staff, regarding legal questions. So really what the program is divided into two parts. The first part is gives you access to our legal resource library. It has all sorts of self-help tools, case updates, and thousands of collective bargaining agreements, MOUs, and salary schedules that are going to be very valuable for you in terms of preparing for your bargaining at the table. It's going to give you a good sense of what your neighboring districts are doing, what their salary schedules are like, what they've agreed to in recent negotiations. And it's also a helpful tool for recruiting and retention, because it allows you to judge, where do you stand with respect to other districts of similar size or location or whatnot, so that it can help you with your recruiting and retention practices. Over the years, you may have contacted our policy team or been in a policy development workshop and asked a question that was answered with, that calls for legal advice. So you're going to need to speak with your legal counsel. Well, one of the other aspects of this program, one that I'm most excited about, is that this program creates an attorney-client relationship that allows the attorneys on our legal services team to serve as that legal counsel for your district. So once you've signed up for the program, you can call us at any point and we will act basically as your own in-house counsel, and we can advise you on a number of things that are all listed here. And that's just sort of a sampling of them. So far, we've been assisting districts with waiver requests, Brown Act requests, and open and closed meetings, how to adjust their agendas, how to handle those. We've done independent investigations on both student and employee discipline issues. And one of the things that's most pertinent to this webinar is we can also help directly with your policies. So whereas before you may have gotten a response that called for legal advice, we would say, I'm sorry, you have to talk to your counsel. Now you can talk to us if you subscribe to that service, which is really beneficial because we are also the experts who are writing these policies. So we've got a lot of insights to that. We can also assist you not just with the CSBA samples and modifying those for your use, but if you need to create your own unique policy that maybe we don't have a sample to start from, our team can assist you with that. Next slide, please. So for many of you, you may already have legal counsel, and I just want to let you know that that doesn't mean you can't subscribe to this program. There's nothing about this program that requires you to seek advice from our attorneys, although when you do sign up, you get 3 hours of attorney time free of charge, and we only bill at $200 an hour after that, which is, if you're familiar with legal costs, an extremely good rate for attorneys. So the idea here is that we're trying to provide cost-effective services for you. But even if you have legal counsel or you never use our attorneys, you still get access to the database. And here's just a screenshot to give you a sense of what it looks like. You can filter it down by the documents you're looking for, type of bargaining unit. This is just our database for our collective bargaining salary schedules and whatnot. So it's a really useful tool that I think is going to be helpful for every district that subscribes. Every member of CSBA, every county office of education can use this, and it goes beyond just getting legal advice. So the cost is minimal. It's only 10% of your annual dues at CSBA. So for most LEAs, that's actually $1,000 or less. It's a very cost-effective program. So we just want to make sure that you guys were aware of that and let you know about the program. Next slide, please. So I guess the question here, why are we on this call, right? The Legal Services Department, if this is a policy thing. And again, it goes to that ability for us to help you with implementing, interpreting, and editing your policies. But I don't want to spend too much more time on that. We're here to collaborate with our policy folks. So I'm going to turn this over to Barbara Leifman, who's going to talk to you about the first policy. And then throughout the course of this webinar, we'll go back and forth between the policy team and the legal services attorneys to explain and advise on these policies. So without further ado, I will turn this over to Barbara.
Okay, thank you, Bob. Next slide, there we go. Next, we'll be discussing the purpose, context, and recent updates to 0420.41 Charter School Oversight. Next slide, please. Let's look at the purpose of our sample policy materials on charter school oversight. District governing boards and county boards of education are obligated to monitor the performance of any charter school it authorizes to ensure the school's compliance with legal requirements and progress toward meeting measurable outcomes specified in the charter. The exhibit lists these legal requirements and may be used by districts and county offices of education to monitor a school's compliance with law. CSBA regularly updates this exhibit to account for new laws applicable to charter schools. So let's now gain an understanding of the recent updates to CSBA Sample Board Policy. We updated the policy in regard to the following sections. So the first section is material revisions to charter. And for the district sample, we clarified that when an approved charter school proposes to expand operations to one or more additional grade levels, the charter school is required to request a material revision and notify the board of the additional locations or grade levels, whether the proposed expansion is concurrent with or unrelated to a renewal. That's the part that we really clarified. It's that the expansion is either concurrent with or unrelated to renewal. The county sample actually didn't have this section at all. So we added the section and of course, with the clarification that I just mentioned for districts. We also made a change to the section fees, charges for supervisorial oversight. In the district version, we created a new section and rearranged the material for clarity regarding when the district may charge for this type of oversight. In the county sample, we changed the heading to reflect that the content is in regard to charges for the provision of services to a charter school. Another change was in the section technical assistance intervention. In the district sample, we provided that it is the county superintendent of schools in specified situations who may request that the superintendent of public instruction assign the California Collaborative for Educational Excellence to provide advice and assistance to a charter school that fails to improve outcomes in regard to state or school priorities identified in the charter. This was already provided for in the county office sample, so there was no need for changes in this regard to the county office materials. Another change was in the section complaints, and this was similar for both the district and county samples. We added that complaints alleging non-compliance with specified education code provisions in regard to the local control and accountability plan may be filed anonymously if the complaint provides evidence or information leading to evidence to support an allegation of non-compliance. And the last change, or more significant change, was in the section monitoring of charter school performance. In the county sample, we clarified that the monitoring of charter school performance requires a determination of whether the school is achieving measurable student outcomes set forth in its charter for both school-wide and all numerically significant student subgroups. This was already provided for in the district sample, so there's no need for changes in this regard to the district materials. Next slide, please. The sample district and county exhibits are recently updated to incorporate many of the changes in law attributable to 2021 legislation that are applicable to charter schools. Mariella will now highlight a few of the key changes.
Hello, everybody. I do have some of these changes, like Barbara said, and I want to go over just the most relevant bills and an attorney general opinion this time around in an effort to help districts and county boards of education monitor the compliance of charter schools. So the first is a new attorney general opinion, and it addresses conflict of interest. And basically provides that it is a conflict of interest for a charter school's executive director or any other employee to serve as a member of the county board in the county where the charter school is located. And this is essentially the same standard that applies to employees of a traditional public school. So next we have AB 27 and SB 400. These two address homeless children and unaccompanied youth. And basically, they provide that charter schools must comply with the requirements of the Ed Code regarding enrollment and identification and placement of homeless children and unaccompanied youth. Let's move on then to SB 224 and mental health instruction. And again, SB 224 provides that instruction in mental health must be included in the charter schools if the charter school serves students in middle or high school and offers one or more courses in health education. Then we're going to move on to financial aid and AB 132, which provides that if the charter school serves students in 12th grade, it must comply with the requirements for completion and submission of the free application for federal student aid and the California DREAM Act application with respect to students who have not opted out. And here comes the big one, AB 130. It has multiple provisions that are worth discussing. The first is the Universal Meal Program, but that will be discussed in detail later in the webinar. So I'm going to jump over that and focus on TK, independent study, and criminal record summary provisions. So TK. AB 130 provides for phased-in starting dates on which a charter school is required to offer a TK program, and that's based on the student's birthday. Next, if the charter school offers TK, credentialed teachers first assigned to a TK class must meet one of 3 specified criteria establishing qualification for the position, and this must take place by August 1, 2023. Finally, with respect to TK, the charter school must maintain adult to student ratios as specified in the education code, and that is dependent on the school year that we are dealing with. Now moving on to independent study. There is an added item regarding the development of a plan for offering independent study to affected students if the governing body of the charter school submits an affidavit pursuant to the Ed Code necessitated by an emergency condition that resulted in a school closure. And finally, we've got the criminal record summary. AB 130 in this regards requires that if a charter school contracts with an entity for specified services, it must verify that any employee of that entity who interacts with students outside of the immediate supervision and control of the student's parent or guardian or a school employee has a valid record summary unless an exception applies. That's pretty much it for me. I will now hand it off to Barbara again for a discussion of district and school websites. So we can go ahead and move on to the next slide.
Thank you, Mariella. So yes, we'll now look at the exhibit to 1113 district and school websites. So let's look a bit at the history and purpose of the exhibit. CSBA's policy manual has had a sample board policy for district and school websites since 2007 and an administrative regulation since 2000. In 2020, we created a sample exhibit as there are now numerous posting requirements and recognized that it would be helpful to have these legal requirements listed and in one place. The exhibit lists materials which the law explicitly requires to be posted. It is regularly updated to account for new laws that change or add posting requirements. We recently updated the exhibit to incorporate posting requirements attributable to 2021 legislation, as well as posting requirements related to posters published by the California Department of Fair Employment and Housing. Next slide, please. Mariella will now highlight a few of the key changes.
Thank you, Barbara. Yes, let me get into some of the changes in that exhibit. And we're going to come back to AB 27, which, if you recall, deals with homeless students. And AB 27 requires the posting of contact information for the liaison for homeless students and other persons. And it also requires the posting of information regarding the educational rights and resources available to persons experiencing homelessness. AB 8 1.9 is a big one. It deals with the California Environmental Quality Act, or CEQA. And it basically provides that when CEQA requires an environmental impact report, a negative declaration, or a mitigated negative declaration, certain things must be posted. And those things are the documents that I just mentioned, in addition to a draft environmental impact report. Second, a public notice of the preparation and availability of such documents. And third, specified notices when written requests for notices have been filed. So that's that for CEQA. Then there are provisions regarding posters published by the California Department of Fair Employment and Housing. So for instance, the poster entitled "California Law Prohibits Workplace Discrimination and Harassment" must be posted. And also in the case of a certain number of employees, also the posters dealing with transgender rights in the workplace, rights and obligations as a pregnant employee, and family care and medical leave and pregnancy disability leave. I will now hand it off to Alex for a discussion of the Williams Uniform Complaint Procedures and Facilities Inspection. So we can move on to that slide for her.
Thank you, Mariella. Okay, so that brings us to the Williams Uniform Complaint Procedures and Facilities Inspection. So we have 3 policies here and some exhibits that have been updated as a result of Assembly Bill 367. So Assembly Bill 367 was part of the 2021 statutes, and it becomes effective July 1, 2022. It requires that all public school districts serving any combination of grades 6 through 12 must provide free menstrual products in specified restrooms beginning in the 2022-2023 school year. So a little bit of history, Education Code 35292.6 previously required that school districts serving any combination of grades 6 through 12 with a 40% pupil poverty threshold must provide menstrual products in 50% of their school restrooms. So AB 367 has expanded this law, and it's removed the poverty threshold. So now, because of AB 367, all school districts, regardless of the poverty threshold, that serves any combination of grades 6 through 12 must provide free menstrual products in specified restrooms. So like I said, because of AB 367, we've made updates to 3 policies and exhibits. And so I'm just going to run through those with you now. Okay, thank you to Zita for switching the slides. As I mentioned, 367 requires menstrual products for schools serving grades 6 through 12. There's a couple of things to note here. Again, the poverty threshold has been removed from this policy. It is no longer required by law for that poverty threshold of 40%. This law also defines menstrual products as menstrual pads and tampons for the use in connection with the menstrual cycle. And then specified restrooms. Recall in the Education Code, it previously required menstrual products to be provided in 50% of the restrooms. AB 367 has specified that these menstrual products must be provided in specified restrooms, including all women's restrooms, all gender restrooms, and at least one men's restroom. And the purpose for this is for inclusion of transgender students and non-binary students. So I want to just point out some of the changes that we've made to the policies. Like I mentioned before, we've got 3 policies that have been changed because of AB 367. So you'll notice the 2 columns on the left are policies and exhibits for school districts. And then we've got a column on the right, which is a policy for county offices of ed. So I'm going to start with AR and exhibit 1312.4, and that is the Williams Uniform Complaint Procedures policy. So just a point of clarification here, I know a lot of times when people hear Uniform Complaint Procedures or UCP, they immediately think discrimination and harassment. Just a note, the Williams Act is a category of UCP complaints that focuses on facilities issues, instructional materials, teacher vacancies, and misassignments. So because the menstrual product requirement falls within the facilities category, it's going to fall under a Williams Act complaint. So that's why we're updating the Williams Act here. So we've got 3 main changes to this policy. You can see those changes in the columns here and then an exhibit at the end. The first change is the actual requirement outlined in AB 367 to provide menstrual products in specified restrooms. We've also got a change here about the UCP complaint, the Williams complaint. A Williams complaint can now be filed if a school district fails to provide those menstrual products in the specified restrooms. And then the third change is more of a point of clarification. It's not an update in law, but we wanted to include here that a written resolution of a Williams complaint must be mailed to the complainant when requested. So typically on the complaint form, the complainant can choose the option to write in their personal address. And if they'd like to receive a written resolution of that complaint, the superintendent's designee must mail it to the complainant with the address that they've provided on the complaint form. So like I said, that change is more of just a point of clarification. And then lastly, we have an exhibit for this policy as well. And it's an update to the Williams UCP complaint form, which now, as you can guess, will include an option to file a complaint for failure to provide required menstrual products. So that brings us to the second policy that we've updated. It's in the second column here. It's AR and Exhibit 3517 for facilities inspection. And this is the policy requiring superintendents to inspect school facilities. Again, because this menstrual product requirement is a facilities issue, we're updating that policy as well. We've got 2 main changes that I want to point out. The first, again, is just the requirement required by AB 367 to provide free menstrual products. We've got a second change that schools must post a notice regarding this requirement in a prominent and conspicuous location. So what that means is that a notice has to be posted in every restroom where menstrual products are being provided. So again, all women's restrooms, all gender restrooms, and at least 1 men's restroom. And then we've got an exhibit attached to this policy as well, and it is a sample of the required notice that school districts can use to post in their restrooms. Okay, and then we've got our last policy that's been updated because of AB 367, and that is the county policy, board policy, regulation, and exhibit. It's very similar to the school district policy 1312.4. We've got some main changes that I've outlined in this chart. Again, the first is the requirement of AB 367. The second is that a Williams complaint can be filed for failure to provide menstrual products. And then you'll notice that we've got 2 exhibits attached to this policy as well. The first is a notice regarding complaint rights. And obviously that's a notice about when you can file a Williams Act complaint. And you may notice that we don't have that exhibit listed for the school district side. It's not because that exhibit doesn't exist. It's simply because it has not been updated in this June packet. So we've not included it in this presentation. However, that exhibit is in existence. So if you need to find it, you can find it on your Gamut website. And then the second exhibit we have updated for this policy is the Williams Uniform Complaint Form, which is again the form that includes an option to file a Williams complaint for failure to provide menstrual products. So Tazita, you can do the next slide, please. And I am going to pass it off to Tazita to cover electronic signatures.
Thanks, Alex. So this one is a little different. So the next policy we're highlighting is electronic signatures, and we've created a sample board policy as well as an administrative regulation that can be found at 3523. So the reason this one is a little different is because this did not emerge out of any significant legal change or change to any statute. This emerged out of just best practices and demand. So from time to time, CSBA does respond directly to requests to develop sample language if we feel that there is a significant need. In this case, over the past 2 years, it's obvious that we've moved more into the virtual world using systems such as Zoom. That also necessitates need to develop more robust policy language around electronic signatures. So that's what we did with this policy. It's a brand new one. So in your packet, you'll see that it didn't exist before. Now it does. Completely new language, and it's optional. So as opposed to some things like uniform complaint procedures or Williams Act, this is one that is completely optional if you want to adopt it and review the language. This is all kind of, again, statute that existed prior to this policy. But here we're just summarizing, again, the authority for districts to use electronic signatures in the operation of any district functions. So these can be used for, or electronic signatures can be used for things and documents that are signed by administrators, as well as parents and guardians, students, employees. And again, no real big changes to the legal language or the legal or any statute here, but what Alex is going to do for us next is just give a summary of the statutory kind of requirements that underlie the policy and review those for you all. So I'll shift back to Alex.
Thank you, Tazita. So as Tazita mentioned, this policy is optional. This policy allows districts to use electronic signatures for the operation of the district. It was based on multiple laws. They are included in the policy, and they are the Uniform Electronic Transactions Act, which is codified in Civil Code 1633.1. Also the Government Code 16.5, which authorizes public entities to use digital or electronic signatures. It also includes the California Code of Regulations 22000 through 22005. And lastly, the Federal Electronic Records and Signatures in Commerce Act. So the main points here is a digital signature is defined as an electronic identifier created by a computer, intended by the party using it to have the same force and effect as a manual signature. Electronic signatures can be used by the district when the parties signing the contract have agreed to use them. Our policy outlines some requirements should a district choose to use electronic signatures. The policy has some outlines, some requirements that we took from Government Code 16.5 if you choose to use an electronic signature. That signature must be unique to the person using it. It must be capable of verification, under the sole control of the person using it, and it must be linked to data in such a way that if the data is changed, the electronic signature becomes invalid. Lastly, the electronic signature must conform to California Code of Regulations 22000 through 22005, which basically outlines additional protections over the creation of an electronic signature, including acceptable technology, the level of scrutiny for identifying the signer, and for transmitting the signature. The policy also notes additional references for when documents must be notarized or signed under penalty of perjury. So our policy will help you with those situations as well. Next slide, please.
Okay, thanks, Alex. So as you can see from the slide, the next content we're going to be discussing is the Universal Meal Program, and it impacts three of our policy materials and sample materials, 3550, 3551, and 3553. So next slide, please. The legislation that created the Universal Meal Program is AB 130, which requires all California public schools to provide a nutritiously adequate breakfast and lunch to each student who requests a meal, regardless of the student's eligibility for a federally reimbursable meal. So as I noted, this legislation impacts three of our food-related sample materials. So it's 3550 Food Service Child Nutrition Program, 3551 Food Service Operations Cafeteria Fund, and 3553 Free and Reduced Price Meals. There's another interesting piece of legislation, which is AB 486, which authorizes the coordination of food service programs with classroom instruction and other related district programs. Although it is not part of the Universal Meal Program, it does impact Board Policy 3550, which is one of the sample policies which was updated in June for purposes of the Universal Meal Program. Next slide, please. The Universal Meal Program is a big change. Bob will now cover some of the open issues and questions, as well as specific changes to our policy materials and legal implications as a result of the change in law.
Thanks, Barbara. So these policies rather, There's a pretty significant overhaul of all of these policies based on the changes in the law, but the changes to the policies themselves are actually pretty straightforward, right? We had to remove a fair amount of language that referenced free and reduced price lunch, but not all of it. We obviously incorporated a lot of language about the new laws. So I'm not going to go through those step by step because it is 3 policies. It's roughly 40-45 pages of material when you include the notes. I'm not going to go through every single one of those changes with you, but rather instead explain sort of the implications of those policies, because they're pretty complex in terms of the balance between state and federal law, and also the further reaching implications from these changes. So again, we removed a lot of the language that referenced free and reduced price lunch from these 3 policies and regulations, because that's now, at least from the student perspective and largely from the parent perspective, a moot issue, because students are entitled to receive 2 free meals each school day upon request. Before, they received meals, as you know, through either the free and reduced price lunch program or through purchasing meals through your LEA, but now they're entitled to those free meals. Under the Education Code, under 49501.5, which was added by AB 130, these meals provided under the California Universal Meals Program have to qualify for federal reimbursement. So that means even though we've got these free meal programs through the state, you still need to participate in the National School Lunch Program and the School Breakfast Program. In order to receive your state reimbursement, and this is important, in order to receive your reimbursements under the California Universal Meal Program, you have to step through the processes of first getting those federal reimbursements. So in order to do that, and that's because the funds here, right, the funds provided by the state under the Universal Meal Program, they're meant to supplement but not supplant federal funds. The idea here is to provide more healthy meals for students, allow them to be able to be more focused at school and not have to worry about things like nutrition while they're trying to learn Common Core math. So that's the idea. And we want to make sure that that is able to happen for all of our students, regardless of their economic status. So the state's taken this pretty extraordinary, pretty unique measure to make sure that that happens. But again, in order to do that, we have to go through this reimbursement program that's a balance between federal and state. So participation in the programs means that both in the federal programs means that both Board Policy 3551 and 3553 on the last screen, they're both conditionally mandated, which means you have to have those policies in writing in order to qualify for the federal refunds. In addition, you also need to make sure that your students are still eligible for free and reduced price meals. And herein lies the challenge, right? Because as we're all familiar with lunch shaming and the fact that discrimination against students who participate in free and reduced price lunch programs is prohibited, it is a concern and a factor that we need to consider in this. Because in the best of times, it's been a challenge to get families to fill out applications for free and reduced price lunches. Now that they receive 2 free meals, regardless of whether or not they've filled out that application, what's their incentive to apply for these free and reduced price meals, right? So from the district or the county office perspective, right, you need to have these applications filled out in order to go through the reimbursement process. But from the parent or the student's perspective, it's really sort of painting a target on them that they're, exposing potentially their economic situation. This is information that is intended to be kept private. It's not something that needs to be disclosed and should not be disclosed, but it's still something that, families and parents in particular are going to be wary of filling out those applications, especially now that they don't have to. So that's why it's real important that you communicate information to your parents and guardians and your community at the beginning of each school year. Make sure that they're aware of what the food programs are. And going back to AB 486, to the extent that you can, you need to coordinate your school meal programs with new nutritional education programs within your schools. These are going to help to get the word out there. Not only does it help to educate the students about healthy choices, but hopefully it's going to help promote people signing up and filling out these applications, because it's going to be critically important that they do that. Under the new program, it's also important to note that you're still allowed to sell meals to adults and also to sell additional meals and snacks to students. So if you've got a voraciously hungry teenager in one of your high school programs who needs more than the 2 meals or wants a second lunch, you're still allowed to provide those and provide those at a charge, as well as healthy snacks consistent with other requirements. So those are some of the things that are important to note about the changes in the law. And now what I want to talk about are some of the changes or the implications of these changes, specifically with those applications, because really what we're dealing with here are unintended consequences. Again, this is a fantastic program, very beneficial for students, for families, for communities in general. I know that there were, during the pandemic, when we were all closing down a few years ago, there are a number of districts that expressed a lot of concern about what happens when we close down our sites. This is a community resource, a place where a lot of students come to get their only meal of the day. This program is critically important to those kind of things, right? To make sure that our students and our communities are looked after and taken care of to the extent that we have that responsibility. But the unintended consequences, free and reduced price lunch applications, touch on a number of additional programs that are going to be impacted by this. Here's a list of them. I've got a few that we can go through here. The local control and accountability plan, for example, your unduplicated students, by definition, include those students who are eligible for free and reduced price meals. That's going to impact your LCFF calculations. It's going to impact your plan. It also is going to impact before and after school programs under Education Code 46120, which ironically was also added by AB 130. We've got the Expanding Learning Opportunities Program. That's a before and after school program. But under that new program, districts are required to prioritize services at school sites in the lowest income communities, as determined by prior year percentages of students eligible for free and reduced price meals. So obviously, if we have fewer people filling out these applications, it's going to impact that prioritization of who gets into these programs. Similarly, Ed Code 84825, 848.5 deals with the ACES program. Also, we've got which deals with their priority. Again, priority needs to go to those schools with at least 50% of students being eligible for free and reduced price meals. This change in law will most likely impact those as well. Similarly, school health services under the Education Code, districts are authorized, not required, but authorized to include information on their application for free and reduced price meals, information about the Medi-Cal program and students' eligibility for that. So this is another place where failure to have those applications could impact students on the broader level because they're not getting that additional exposure to their potential eligibility for Medi-Cal. Preschool, early childhood education, that's going to be impacted as well. A California state preschool program that's operating within the attendance boundary of a school where at least 80% of your students are eligible for free and reduced price lunches can also enroll 4-year-old children after all of the other eligible children in your district have been enrolled. However, again, if we're not hitting that 80% threshold, that's going to impact that. So that could have an impact on students who would otherwise not be eligible for these programs if we don't hit that threshold. I could go through a whole list of them here, just a couple others that are worth noting. Transportation fees that are waived for students with demonstrated financial need under Ed Code 39807.5. That eligibility is also tied to free and reduced price lunch programs and applications, as are intra-district enrollment agreements. students who are eligible for free and reduced price meals who enroll in a district school outside of their attendance area as a result of being a victim from bullying, they are eligible for transportation assistance as well. So we've got two components there: the victim of being a bullying incident, as well as eligibility for free and reduced price lunch. Two stigmas that most students are going to want to avoid. And therefore that's going to have an impact there. And inter-district attendance will also be adjusted or impacted by this, rather, because the priority for transferring under the school district of choice program is given to first those students who have siblings who are already attending a district. Second, students who are eligible for free and reduced price meals. Their priority goes to children of military personnel, but that second one is going to be, again, an important prong of this. So as the cartoon sort of demonstrates here, no good deed goes unpunished. And if it happens to sneak by that you are unpunished, you'll maybe pay for it later, who knows? But that could be our case with this program, where the intent is good, the outcome will be good, but it is going to create a ripple effect. Dropping a pebble into a lake and watching that reverberate across the surface of the stream or the lake is going to be pretty evident here. And so unless and until some of these laws change, it's going to be critically important that as the LEA, you're finding ways to still encourage participation in the free and reduced price lunch program in terms of getting people to fill out those applications. And that is going to present a challenge. So communication to parents, guardians, again, at the beginning of the school year is going to be very, very important on that front. And I think that is all we have on this one. So I will turn it over now to Tazita for our Q&A session.
Thanks, Bob. So you've received a lot of information. Again, I want to reference that these are all policies that are available via our sample update packets that was released for counties last week and the prior week for school districts. If you have any questions, now would be a great time to pop those into the chat. I don't see any so far, so I'd love to just maybe give you guys a second here to think of any that have come up for you in the course of the conversation today, and go ahead and enter those when you can. Again, the menu at the bottom of your screen is where you'll be able to see those that Q&A section. So the first question, we will definitely send out a copy of the meeting itself. If you want to receive a copy of the actual PowerPoint presentation, I'll have our emails on the next slide, and you can definitely shoot us an email and I'd be happy to send it over to you. So just again, a little bit of information about our policy services, because we didn't go too deep into that, but Gamut has recently switched to a new platform, which we launched about 2 years ago. We're very excited about all of the capabilities and features within the system. You'll notice that some of the formatting has changed, as well as the attachments that usually come with your update packet. And so if you have any questions or concerns about how to access this information, how to provide information to the staff, or usernames, passwords, you can always reach out to our Gamut team at gamut@csba.org. So for anyone requesting a copy of the PowerPoint presentation, we'll be making sure to get you those if you put your email or put your contact information into the chat, or reach out to us via one of the forms of contact provided at the end in the last slide. So I have another question here in the chat. It would also be helpful if you're interested in providing information about your district in the chat. That's helpful sometimes for us to give us context. So this first question comes from a member who says it's been challenging creating a workflow for the quarterly policy updates. Is there an approach that CSBA would advise will you all take when these updates are released? So again, the question is, what should you be doing with these packets when you get them? I can start, and then I definitely would be happy to open it up to anyone else who had thoughts. But we definitely recommend that you are taking these quarterly to your board. How you do that really depends on the structure at your district or county office, or LEA office if you're an ROP. So sometimes a district might have a policy subcommittee. Other times there is a point person who is available to distribute these to the proper cabinet level staff. If it's a smaller district, that might be a team of one. So our recommendation again is that you're taking the CSBA sample language if you have Gamut Policy Plus, making any revisions that you have in the system. Prior to that, you want to circulate that again to review the changes that CSBA has made. If it's a new policy for you altogether, it might be reviewing it for consistency with your district practices or county office practices, and then making any tweaks or changes. We recommend a first and second reading for the board to review the changes. And at that second reading is when you're going to adopt the language. You can go ahead and plug those adoption dates right into our new system and publish those yourselves if you are the administrator or the point person appointed at the district level. So again, I don't think that gives you a prescriptive process, but again, the idea being that you're at least engaging with policy updates 4 times a year at the very least. If there's a need to spread that out further so that your board can kind of really wrap their heads around those changes, that's also a possibility, but at the very least, reviewing them consistently 4 times a year for CSBA's changes, any changes to your district practices that might be necessary, and then taking those to your board for first and second reading. Bob, did you want to, or anyone else want to chime in on that question? No, okay. I'll go ahead and move to the next question. Most of these are requests for the PowerPoint, and we'll definitely be making sure to do that. I noticed that some of these are coming in via chat, so we don't have a way of logging all of the requests to the chat, so I might just ask for you to log those in the Q&A section if you can. If not, I will try to really quickly capture all of the all of the questions or the emails submitted into the chat so that I can make sure to get you the PowerPoint. So next question is, will we have these workshops every time we have board updates? And I'm glad to hear that the session was helpful to you. And yes, the answer is this is the first of our, I guess it would be quarterly webinar series. So the next one that you'll have access to will come to you in December when we release our December packet. And the schedule will typically follow the update packet. So we do a release for districts, and then that follows that is the release for county offices. And then the following week will be our webinar presentation. So this is the first of many, many to come.
Tazita, I just wanted to pop in real quick and comment on the earlier question. My camera and internet cut out, but
no problem.
As far as the process for making sure you're getting these policies updated, quarterly is a lot. We used to do it 5 times a year. We actually reduced it to quarterly because we know it is a big burden, especially with everything going on in the world these days. But it really is important that you find a method, and our consultants are happy to work with you on what works best for your district and sort of talk through options, whether it's having a subcommittee that meets regularly, setting up special meetings, or just making sure that you tackle some policies on every single agenda just as a matter of course. Because staying on top of these, not only does it actually reduce quite a lot of stress. If you've ever been through a policy development workshop, it's pretty overwhelming to try and tackle huge chunks of updates all at once. But it also reduces costs for the district, not just in terms of having to pay for doing something like a workshop, but potential liability, right? If some of these policies, you might look at them and think, we just have to adopt this. It's just kind of a rubber stamp activity, but they're far more important than that. Because the first thing I can tell you as somebody who used to litigate against government entities all the time, one of the first things I would always ask for is, let me see your internal policy. Because if you're not operating consistent with it, or your policy is not consistent with the law, it's an easy place for you to suffer in terms of litigation and liability. So it's something that it's important for you to stay on top of, definitely. So we can work with you again to help out with figuring out those processes for what works best for your district, because every district and every board is going to want to approach that differently. It's just important that you set and establish a practice and you stick to it.
So we have another question here. If a BP or AR is not on the mandated list, can we assume they're optional? Barbara, do you want to take this one?
Sure. Yes, basically, yes. We do also have what are considered conditionally mandated policies, which means that if you offer that program or the material of what the content of the policy is, then it is mandated to have that policy in place. So, and we do have a mandated and conditionally mandated list, which is very helpful. It's a chart which outlines the policy or regulation, a little bit about the content and what the code sections are that create the mandate. So, but yes, otherwise, the policies are optional. I will say though, as a board member, a prior board member, a lot of the optional policies are extremely helpful. They add structure and, eliminate some form of ambiguity in how a lot of things are going to be addressed. So I hope that's clear enough. But please chat more if there's something more you'd like to know.
I think just to build on that as well, Barbara, that just because a policy is optional doesn't mean the laws which it references are optional, right? If you a mandated policy means thou shalt have it in writing. It doesn't mean that you're excused from following the law that's spelled out in the other policies. So they're helpful tools both for your staff, but also for your students, for your community, and for you to look up resources, right? Without having to go and research the ed code each time. So optional policies, if they apply to your district, can always be very beneficial for you to keep, even if they're not mandated or conditionally mandated.
Thanks, Bob. So another question, if we are creating a new policy, is there any way that we can create a draft directly from the CSBA sample instead of copying and pasting? So I can start here. This is a little bit of a technical question about the system. So if you are a GPP subscriber, you have your own site. In that site, you're able to copy from our sample policies. I can definitely kind of have someone walk you through, Eva, the process of doing that, but just in a nutshell, if you're saying new policy by that you mean something that the district created on their own, then no, you wouldn't be able to copy and paste. But if you're saying new policy, like for example, the one on electronic signatures, if that exists in our samples, there's a way for you to copy that exact language over into your drafts. Once you have it in your drafts, you don't have to format anything. You can just go in and make any necessary edits to reflect your district practice. So if it was something that you never had before, but if it was something that CSBA had sample language on, like I mentioned, the one on electronic signatures would be brand new. So it's possible that you don't have any language on it yet. If you wanted to have that language, yes, you could copy that straight from our samples using a feature in the system. So you don't have to kind of select all the text, copy it, paste it. There's a new little feature and it looks kind of just like a carbon copy when you go into the CSBA communication section and you click on the update packet, you can copy over directly from the update packet into your district samples. So I would really encourage you to reach out to our Gamut support team, because we can walk you through the process from beginning to end and kind of do that with you the first time around if you need additional assistance. So I will try to send you that direct link or email contact in the chat, Eva, so that I can make sure we follow up to make sure you get that assistance if you need it.
And if it's a unique policy that's truly unique to your district that you're building for the first time, we can add those as well. We just need to work with you to learn the title and figure out a numbering place to put it within the catalog of policies so that it will show up in your policy manual. So just work with our Gamut team and they can help you out with that.
And the only difference there, Eva, would be that you couldn't copy anything over, right? There'd be nothing to copy because we don't have any samples. You'll also see that sometimes there are district-specific or county-specific policies that are housed within our manual. Those are demarcated by a little caret, that little symbol that comes before the text. So those, we wouldn't have any CSBA sample language for you to copy over, but you're entitled to or welcome to use those titles if they're appropriate for the policy that you're creating. So that's just the one scenario where we wouldn't be able to give you language to copy. So I hope that addresses the question. The next one we have up is a first reading at a board meeting required, or are there exceptions when a BP can be approved at one meeting? So I will throw that out to anyone on our legal services team who wants to chime in there.
I'd be happy to chime in if you two don't want to speak up. For those of you who don't know, I used to be in the policy department, so this is my wheelhouse. I love the policy world. There's absolutely no legal requirement for a first reading and then a second reading for adoption. As long as your policies are placed on the agenda properly as an action item, you can take action on the first reading. It's generally frowned upon because as a board, right, you're meeting for the first time to review these materials, and this gives you the chance to dialogue, have questions answered, sunshine this to the public so they can see what the policies and regulations are going to be. And a lot of times you need some time to marinate on that and what it might be meaning for your district, right? Because again, policies, far too often, I think people will receive policies and think, oh, we got to adopt these. And they just kind of go through the motions of doing it. But really, for policies to be effective, for them to have an effective impact on your district and on your students and their performance and your budgets, you need to consider what are the implications of those policies and not just going through the motions of adopting them. So by putting it on there for first reading, having dialogue if there is any, and then going back to reconsider it, it allows you that time to really have critical thought. I know as a former board member, you get that packet and it's a lot of material coming at you, and it's kind of hard to digest that all right before one meeting. So that first reading, second reading for adoption is really a best practice, but absolutely not legally required.
And yeah, just a little to add based on past experience, Bob, I entirely agree with your personal thoughts. And we would sometimes even go beyond a second reading. If it, if the content, sometimes we were really contemplating exact language, or maybe it was something a little more controversial. We just really wanted to make sure we were really thinking through the issue as much as we could. We would sometimes go beyond a second reading, and we would also sometimes even just kind of put it on hold and have staff investigate more or give us more information. So I agree with Bob that the more thought that a board does have time to put into policy is a very good thing.
Thank you, Barbara. And we have another question. This may be a duplicate that was put both in the chat and Q&A, but I want to bring it back just because there's something unique here. So the question is, how do we know when it's a mandated policy change? Is that specified on the quarterly update notice? So I think this is kind of a distinction from, is it mandated, or how do we know if something's mandated or not? And I'll start us off. So typically you'll have a note box at the top of each policy in the version that's shared with you, and it will denote whether or not it is a mandated policy. Now, whether or not the changes that we have made are mandated or not, I think gets into a little bit of nuance. The best way to stay up to date with the law and best practice is to update when CSBA makes an update. Otherwise, there's the chance that you would be referring to or relying on outdated information. So I'm interested to see what other panelists have to say about whether or not every change is a mandated change within a mandated policy. It's not consistent from one to the other, but any thoughts on that?
Yeah, I mean, usually it's, well, it can be either. Sometimes it's just a blanket statement that a district has, is mandated to have policy on an issue. And other times there's actually, like for independent study, very, very, very specific items and content that needs to be in that policy. So it can be either. And in terms of knowing how it gets changed, I believe districts are still getting the mandate list and a red line version, which will show when we distribute the updates, which will show if there have been changes to a particular mandate.
So that's a great summary place to look for information about specific mandates that each of the policies or regulations or exhibits cover. One of the things I'll say about the recommended changes is CSBA, when we revise a policy, we're not going to just revise it usually for one item. We do a thorough review, mostly because we want to make sure that we're not missing anything if best practices have changed, or just to be consistent and current. So when we're making changes, there's let's say an optional policy, should you then process an update. Again, the idea being that you would try to keep them as up to date as possible, not wanting to rely on old information. If we're changing small nuances within the policy, you're going to see that change come back again and again many times over in subsequent updates. So I often think it's best to capture it when we do it. But if that presents a hardship for a district, I could understand why you would not want to go in and make kind of formatting changes. But again, the idea is if you're using Gamut Policy Plus, you have the ability to copy and paste those directly into your system, which I believe makes it a little bit quicker and easier to process changes. That can be a little bit more into the minutia of things. But again, as Barbara said, the essential mandated changes are captured on our mandated policies list, which is available to you within the Gamut system. So it's no longer mailed with the update packets, but it is accessible within the system or by request.
And I think that those are some key resources, right? And another one is the guide sheet that gets published with each of the updates. That guide sheet gives you a quick, like 3-4 sentence summary of what we changed. And 90% of the time, those changes are directly because of a change in the law. So even if it's an optional policy, if the law has changed and your optional policy is reflecting language of the old law, you run the risk of having a policy that's inconsistent with law. Now, some people might look at that and say, well, then why have the optional policy? Let's just go with the law. The idea, again, is like the policy is a useful tool for you. If you keep them updated and current, they're a reference point for people who may not know or want to read through the ed code. For parents, for students, for staff, it's an accountability measure. It also sets a tone for your district. So are they all mandated to update? Not necessarily, but you should be doing those updates as they come out. That guide sheet's a great way for you to take a quick look and see what changed and why. You also have the ability to ask our consultants, or if you subscribe to legal services, you can always call one of our attorneys and we walk you through the changes and what your current policy is and help you with any of those adjustments if you need assistance with that. So there are resources for you on that.
Thanks, Bob. So our next question is, do administrative regulations need to be adopted or just board policies? I understand ARs are taken to the board, but do they need action? Good question.
Great question.
Bob, do you want to take a stab at that one?
Sure. So technically, policies have to be adopted. Administrative regulations fall within the purview of the superintendent generally, right? So they don't have to be adopted. It is a good practice to bring them before the board for approval. So you'll see actually at the bottom of our policies, I think they still say this, adopted for board policy, approved for regulations, because the difference between a regulation and a policy for most people in terms of their adoption and how they're sunshine to the world is a non-issue. They want to know what the policy is, what the procedures are, so that they know how to follow them and what the district is doing. So do they have to be approved? Not necessarily. However, there are a few sort of gray areas on this. When you look at something like uniform complaint procedures, the law is written to say that a district must have procedures in place. So is that a policy or a regulation? That's questionable, right? There are some areas in the law like that where they use language that is not particularly clear. So as a best practice, I think it's a good idea to bring those board policies forward for adoption, bring your approvals or your regulations forward for approval so that you can show that there's some sort of board action in case there is a gray area or a place where someone says, hey, do you have this policy in place? Or did you adopt a regulation or a procedure as required? So I think it's always the best practice. And also because you want people to know what you're doing, right? So you might as well be bringing it before the board.
Awesome. Thanks, Bob. So we don't have any other questions. We have a couple more minutes if you do want to offer up anything, and it could be very general to very specific. I'm happy to try to use this time we have with you guys wisely. Otherwise, just a couple wrapping up things. I want to say that the policies and the updates are put together by a big group of people, only of which a few are represented here today. So I just wanted to just give a really big thank you to our team that works on these painstakingly throughout the year to bring them to you and make sure that they're available and accessible. We have a great team of attorneys that we work with, as well as kind of specialists and technicians who do really great work, we think, and work that we're proud of. So if you have any questions at all about that process or how to improve it, thoughts about the system itself, we really do want to encourage the feedback. So I'm going to go ahead and post our contact information The first two emails, our first email and website is for legal services. So if you're interested in any of the services that Bob mentioned earlier on, and many that probably he didn't even cover, you can reach out to their team at legalservices@csba.org and find more information about their services and the subscription portion at legalservices.csba.org. On the Gamut side and the policy access, technical questions, passwords, logins, things like that, we have a team that is there to give you support, especially in the transition to the new system. They can be contacted at gamut@csba.org. The only email that I didn't include on here, which I wish I had, is policy@csba.org. A pretty important one because that's where we field most of your questions about policy. And you can get in touch with any of our consultants as well as myself via that email inbox with any questions that are not legal questions, and we'll do our best to answer them. I think we have a couple more questions that have come up here. The recorded video will be sent automatically to all attendees. And thanks for providing your email in the Q&A portion if you'd like to receive a copy of the presentation itself. There's been so many requests in the chat for the presentation. I probably will just kind of wrap it up, make it pretty, and send it out to you guys automatically. So don't have to worry anymore about sending your emails, because we're going to just do that along with the presentation, because it seems like you guys want and need it. For our panelists, if you haven't seen in the chat, people, I do think this is helpful. So I just want to say thanks to our panelists for being with us today and sharing this really important, relevant information to our districts and other LEAs. Anyone else have any parting remarks for our attendees?
I've got just one quick thing to add. First of all, thank you again for being here. This is near and dear to my heart, but also real important to our districts, our members, our students. So thank you guys for the work that you're doing. I also wanted to just note, for those of you who have noticed or paid attention to some of the Supreme Court rulings of late, there are two that are going to impact schools dramatically. One of them is a case called Kennedy versus Bremerton Unified School District. And we're looking at that case right now in the ruling and sort of sussing through how is that going to impact your policies and in your districts directly. So an analysis of that will be coming out from CSBA if you do have questions about it. If you subscribe to legal services, we can help you directly address those issues and sort of field questions about how is this new ruling going to impact schools. For those of you who don't know, it changes the landscape around exercise of religion and prayer in schools, and exactly how far reaching those implications are still a little bit of a gray area. But again, we'll be sending out an analysis of that here pretty soon from CSBA, and legal services clients will be able to get additional information as well.
Thanks, Bob. And, you know, we understand that folks are living in tumultuous times. We appreciate your attendance today. We hope this information has been informative and helpful to you. Please do contact us if there are any questions, concerns, feedback you want to give us. Otherwise, thanks for your attendance today, and we'll see you on the next one in December.